Yes.
Lords, my ladies, before the short adjournment, I pointed out to you the scale of what the appellant's asking the court to do and approve. It would rewrite this statutory scheme, as I said, for anyone working less than 46.4 weeks a year, including, it appears, the salaried staff of the appellant. And in that respect, the lack of clarity in the appellant scheme, for the reasons we've given in writing, must be a matter of serious concern. And a point which is not resolved in the Learned Friend submissions is the position of the workers in the Russell and Transocean case, which is referred to in Lord Justice Underhill's judgment. I don't ask you to turn it up. The reference is paragraph 57 at page 205. Those are the offshore oil rig workers who worked 12 hours a day for half the year when on the oil rigs, typically 2 weeks on and 2 weeks off. So on the appellant's analysis, they are part-year workers as well, because they worked on 26 weeks, albeit for very long hours, over compressed periods. And the question that's raised at paragraph 77 of Lord Justice Underhill's judgment, and in the intervener's case, paragraph 42 on page 175, the appellant scheme would apply to these workers, but how much holiday do they get and how is it worked out? Is it worked out on weeks of work, hours of work? What is the ultimate outcome in that case? That was a case, of course, in which, as Lord Justice Underhill pointed out, it appears to have been assumed to the level of this court that they were entitled to 5.6 weeks. But in any event, Lord Justice Underhill said that that was not an issue, given the point hadn't been raised by the parties. But still, these workers, the offshore oil rig workers, would be subject to this scheme. Lords and ladies, the appellant's case therefore requires a comparison of the circumstances of each and every worker with this paradigm of the 46.4-week worker, including not just those engaged on permanent contracts, but also those engaged on short-term contracts. There are other examples of workers given at paragraphs 49 and 50 of the intervener's case, citing this court's judgment in the Uber and Aslam case, paragraph 91 of Lord Legate's judgment, at page 837. Again, I don't ask you to turn it up because it's simply classes of workers who, unlike the respondent, Mrs. Brazel, and the salaried staff, do not have permanent contracts, but who work on short-term, discrete, individual contracts. Again, the appellant's scheme, the basis upon which the appellant puts its case that there must be accrual on this basis, would apply to them too. And so how the provisions in Regulation 14 on termination part year and Regulation 15A on taking leave during the first year would operate on those workers on short-term contracts, always effectively in the first year, that's of particular importance, and I'll show you those provisions in a moment. Contrast, though, for a moment, the so-called anomalies put forward by my learned friend, in particular, the worker who works for only a very few weeks every year, but under a permanent contract, it appears. There's no evidence as to these cases, and they're not demonstrated by the situations in the case law. Lord Justice Underhill made this point at paragraph 71 of his judgment at page 209. Indeed, picking up on what my Lord Burrows said about interventions, it's now 2 years since the Court of Appeal's judgment and 18 months or so since permission was granted to appeal to this court, but there are no interventions by anyone seeking to say the Court of Appeal's judgment gives rise to the sorts of anomalies now being suggested by the appellant regarding workers who work very few weeks a year but are still employed on permanent contracts. The point that Lord Justice Underhill correctly, with respect to him, correctly made was that those who do work for only a few weeks a year are unlikely to be employed on permanent contracts. So the anomalies suggested by my learned friend are unlikely to arise in practice, and there's nothing to evidence the contrary situation in this case. In any event, the Court of Appeal was, in our submission, correct to hold that any apparently anomalous results were not sufficient to justify the proposed rewriting of the scheme in the working time regulations. But in any event, these are hypothetical cases without evidence. Can I turn then to the scheme of the working time regulations? In our submission, Lord Justice Underhill was right to say, paragraph 72 of his judgment, that on any natural construction, the working time regulations make no provision of the sort contended for by the appellant. And I'd like to take you back in some cases, and for the first time in others, the key provisions of the working time regulations, and highlight the features of this statutory scheme which are, in our submission, inconsistent with the appellant's arguments on construction and inconsistent with its proposed accrual scheme. And the points are set out in more detail at paragraphs 19 to 54 of our written case. Can I take you first of all to Regulation 13 at bundle page 579. So Regulation 13, as you've seen, contains a statement that a worker is entitled to 4 weeks annual leave in each year. The only exception to that is set out in subparagraph 5, which is where the employment begins during the leave year, when that entitlement is qualified as a function of the proportion of the expired leave year. There's also, Mr. Ford reminds me, not the amount of work. I hope that was implicit in what I said. It's not the amount of work, and indeed nowhere in this scheme is it qualified by the amount of work. I make that clear. So when I refer to qualifications, they are qualifications which are not the appellant's qualifications, and are indeed to the opposite effect. Former paragraph 7, which is the paragraph, as my learned friend said, repealed after the Beck-II judgment regarding taking leave in the initial stages of employment, also referred to an entitlement conferred on the worker. That's at page 598. I don't ask you to turn it up, but again, the language is of entitlement. There's no reference in Regulation 13 to the 4 weeks of leave accruing based on any concept, including the amount of work performed, or for that matter, time elapsed, because the even subparagraph 5 merely qualifies the entitlement by reference to the proportion of the expired leave year at which the employment starts. So there's no accrual during the course of employment at all in this regulation. And we submit that if there was a link between the amount of work performed during the year and the amount of the entitlement, then these regulations would say so and would have to contain a scheme involving the legislator making choices about how the scheme is to operate and how the entitlement is to arise. And the working time regulations do not.
Is everybody acting under the ACAS guidance? And if so, can you just remind me when the ACAS guidance appeared?
The ACAS guidance, I'm not sure when it first appeared. It was certainly in place for a long time, as my learned friend said, until the Employment Appeals Tribunal's judgment in this case. Mm-hmm. But, I'm sorry, my lady.
No, and the ACAS presumably got it from somewhere.
Well, I assume they did, but if ACAS issued guidance which is incorrect, as found by the Employment Appeals Tribunal, the Court of Appeal,
not an answer.
It's not an answer.
But on the other hand, one would have expected them to be advised, possibly. Does it fit in with the EU cases?
Lady, no. What the ACAS guidance in the use of 12.07% is the ratio that my learned friends referred to between the full year 46.4 and the remaining 5.6. Quite where they got that from, one doesn't know. But in any event, it doesn't include on its face a concept of accrual, because it simply applies a ratio.
Could I, at some stage when you're looking at the working time regulations, and I don't want to take you out of order, but will you answer the submission made that there was an express importation into the regulations in Regulation 2.2 of the meaning of week from the Working Time Directive?
Lord, yes, Mr. Ford.
You take it at the stage you plan to take it, but it's a point that I would want covered.
It will be. Mr. Ford, I think, agree with that in his submissions.
Thank you.
But the headline point you'll be unsurprised, Lord, is that this does not import any scheme of accrual. It's not sufficient. The language is not sufficient, whether Regulation 2.2 or Regulation 2.2 read in conjunction with the other regulations, to import a system of accrual of the basis sought by the appellant into these regulations.
Can I just make sure I understand what you submit 4 weeks annual leave means? for a worker who works 2 days a week?
Well, they're entitled to 4 weeks of leave as a function of they're entitled to 4 weeks of leave. They will therefore be resting for 2 days each week because that's the pattern of that's how they work. They're entitled to 4 weeks of leave. The fact that they work for fewer than 5 days or 6 days does not affect the entitlement to 4 weeks.
So they're entitled not to come into work at all over 4 weeks. And that means that, in fact, each week, 2 of those days are leave, and the other 3 are not really leave because they wouldn't have been working for them anyway. But it's still 4 weeks of leave.
Yes.
And can I just understand, when you say there's no accrual, what you mean is that as soon as you start work,
Yes,
subject to the proportion of, on day one, you are entitled to a certain number of weeks leave. It's the remaining proportion of the 4 weeks, depending on how early or late into the year you start, and you're entitled to that leave. And then January the 1st on the next year, you're entitled to 4 weeks leave. And then if you resign during that year, then there's some calculation that has to be made. But you say leave isn't accrued as you work, in the sense.
Yes, Milady, that's quite right. To use the language of the former regulation, it's an entitlement conferred at the beginning of the relationship, and we'll see how the legislator has chosen to recognise that in the various provisions of the WTR, including particularly Regulation 15A. So, my lady's quite right. Subject to the notice requirements in Regulation 15 and the first year requirements in Regulation 15A, a worker can take the whole period of leave in, for example, the first 2 or 3 months of the leave year. There's no accrual. They might indeed be required by their employer for their employer's purposes to take the leave at that point. The learned friend said, as I understood him in his submissions, that that a worker could only take, or should only be able to take, the leave which they had accrued on his analysis at the point in time of the year in which they sought to take it. That is, in our submission, fundamentally inconsistent with this statutory scheme. And can I return to Regulation 13, and I'll come on to the other parts which show that you can take the leave, as I've said. Regulation 13, paragraph 9 on page 579 is important because it requires the leave to be taken in the year which it is due. On the appellant's arguments, the worker and the employer will not know the amount of leave which is accrued in any particular case on this accrual basis until the end of the leave year, by which time it may be too late to take it. Learned friend this morning, I think, said that it was one could keep a running tally of 12.07% of one's working time. Well, the first question, that begs the question in any event, what is working time for these purposes, and who's going to keep this tally of potentially every minute or hour worked throughout the year, so we can have an up-to-date calculation of holiday entitlement on an accrual basis between day 1 and day 365. Can I turn to Regulation 13A, page 581? This is as my learned friend said, this is the domestic provision. It similarly refers to an entitlement to the additional period of leave, similarly qualified as a function of the proportion of the expired leave year and without a reference to accrual. It's not derived from EU law. For your note, the enabling act is at EF 107 and the amendment regulations are at EF 528. And learned friend said that this regulation should be construed in the same way as he sought to construe Regulation 13. I'll come on to that point in due course when I deal with the cases on construction, but the cases in my submission do not support what he said about that, given the way in which the language is expressed in the statute. Can I turn to Regulation 14 on page 583, That, as you've seen, deals with the situation in which a worker's employment ends during the leave year. The payments on termination going either way under Regulation 1 and Regulation 4 are based on the leave taken versus the proportion of the leave year expired. Again, a function of time, not work. And the formula for the payment to the worker in paragraphs 2 and 3 assumes, we submit, as its basis a specific entitlement for all workers, and is not consistent with there being a scheme of accrual as proposed by the appellant. And indeed, how does the formula operate if the entitlement can only be known at the end of the leave year? And coming back to the point I discussed with my Lady Rose, this regulation demonstrates it's permissible for a worker to take leave in excess of what my learned friend says they'd be entitled to, because you can take the whole period of leave during the leave year. Paragraph 4 provides that payment can be made to the employer when the proportion of leave taken exceeds the proportion of the leave year which has expired. And it's unclear if the primary regulations, 13 and 13A, include the accrual conformity principle, the accrual basis, however you call it, how that is to interact with the payment on termination provision in paragraph 4, which is a function of the expired leave year. The two are different.
So is what you're saying that because 14.4 contemplates that the worker might owe the employer money or work because they've actually taken more leave than they have earned, the fact that that's regarded as a possibility shows that it's not an accrual system generally, because they may have taken the whole 4 weeks and then they leave and then they resign.
Yes.
And they owe halfway through the year and they owe 2 weeks worth of pay.
Exactly, my lady. And the basis upon which this provision is premised, which is a function of expired time in the leave year, is not consistent with accrual being the basis for the right arising. Its premise is, in our submission clearly, the right arises at the beginning of the leave year. Regulation 15, turning to page 584, that again repeatedly refers to an entitlement. This is the dates on which leave is taken. I referred to this earlier. Provides for notices to be given by both the worker and the employer as to the dates on which leave is to be taken or cannot be taken. It provides in paragraph 3A that the notice may relate to all or part of the leave to which a worker is entitled during the leave year. But how, one asks, is the notice to be given for all the leave to which they're entitled during the leave year if their entitlement is not known until the end of the leave year? Paragraph 4, notice must be given a specified period in advance of taking the leave so that the employer has sufficient notice. But again, how can that work if the amount of leave is only known at the end of the year? Regulation 15A on page 586 is the provision dealing with the first year of employment. Now, this does include reference to the concept of accrual, but we've set this out in our written case in more detail. You should, we submit, consider the words chosen by the legislator carefully, particularly paragraph 1. This provision does not, we submit, reduce the entitlement that is otherwise arrived at by the operation of regulations 13 and 13A in the case of a first-year worker, nor does it provide that the entitlement accrues, my lords and ladies, in any way at all. It provides instead that the amount of leave that may be taken is limited to that which is deemed to have accrued at the rate of 1/12 of the amount specified in those regulations on the first day of each month of the leave year. And that, again, firstly doesn't amend the entitlement, and proceeds on the premise there is the basic entitlement, as we say, and secondly has no link with the amount of work actually done by the worker. It is, we submit, fundamentally inconsistent with the scheme of accrual proposed by the appellant. If leave, in fact, accrues during the leave year as a function of work actually done, what need is there for Regulation 15A, which operates on the premise the worker could otherwise take the whole period of leave at the beginning of the first year of employment? Can I turn to Regulation 16? That is payments in respect to period of leave. That's on page 587. Again, that refers to an entitlement to leave and introduces a week's pay as the rate of pay for each week of leave, requires the worker to be paid at the rate of a week's pay for each week of leave. This is a familiar concept, as you've seen from the written submissions to employment tribunals. It incorporates in paragraph 2, sections 221 to 224, but not, we point out, section 229, which certainly in the court below was relied on by the appellant, and there was some reference to it by my learned friend this morning, although the way in which section 229 might operate to assist the appellant's case was not really developed by my learned friend in his submissions. Finally, can I take you to regulation 26A? That is at page 590. That deals with the situation where, as at the 1st of October 2007, which is when the amending regulations introducing the 1.6 weeks additional leave came in, there was already an entitlement under a contract, to put it neutrally, to that period of leave. The intervener points out, and we think this is a good point in this respect, at paragraph 48, subparagraph 2 of its case, at 177 for your note, how is this provision to operate in the context of the appellant's new scheme? It seems that the tribunal would need to calculate the contractual leave as its leave entitlement as it stood on the 1st of October 2007 on the basis of the appellant's new system of accrual in order to determine whether the 1.6 weeks additional leave was or was not already given. Can I turn briefly, because I'm conscious of the time, to the rules on a week's pay? These were set out by Lord Justice Underhill at paragraphs 19 to 23 of his judgment, and in our written case at paragraphs 35 to 40 for your note 133 to 134. As I've already said, sections 221 to 224 are incorporated by Regulation 16. Lord Justice Underhill set out the different bases of calculation in the Employment Rights Act, paragraph 20 of his judgment. I don't propose to repeat them. And in this case, it's section 224 of the Employment Rights Act that's applicable because the respondent, Mrs. Brazel, had no normal working hours. And the appellant's case below, at least, although not set out in his written case and only briefly adverted to by my learned friend in his submissions this morning, was that section 229 can be used to modify in some way the amount of pay otherwise arrived at under section 224 in order to achieve the result it seeks, even without any modification, to use a neutral term, to the underlying entitlement in the regulations. To the extent that argument was pursued, and I don't really think it was, or if it was vaguely pursued, that's not permissible for the reasons given in our case at paragraphs 80 to 84 and by Lord Justice Underhill at paragraph 74 of his judgment. In short, firstly, it would result in a reduction in the level of pay used to pay the statutory entitlement, which is contrary to European law in the case of Hine, which Mr. Glynn referred to, Mr. Ford will take you to in due course. And secondly, as my Lady Rose, I think it was, said to my learned friend, the language of section 229 is simply not apt to cover such a general dispensing result. It's dealing with things such as annual bonuses. This is not a general power to substitute a wholly different mechanism for calculating a week's pay to that which appears in the other provisions of the Employment Rights Act. And that's even assuming, against me, that the working time regulations incorporate it when Regulation 16 does not. But in any event, it simply can't serve to achieve the result the appellant seeks, even if we've been told, which we haven't, what the method is by which Section 229 reaches that result. So I don't need to... the case which is referred to in my learned friend's written case on this question from the late 1970s in the Employment Appeals Tribunal is inapposite for the reasons we've set out in our written submissions.
If that doesn't apply, if when you look back over the 12 weeks, one of those weeks you got a £500 bonus for work that you'd done over the year, you would just add that into the averaging and end up with a very substantial average pay?
Lady, that would be the consequence, but Section 229 is not incorporated by Regulation 16. It says Sections 221 to 224.
Mr. Garrick, one of the submissions which either you or Mr. Ford is going to meet is the importation from the directive into the regulations of the meaning of week. Is there a definition of week for the purposes of Section 224 of the Employment Rights Act?
Yes, there is.
The section is on page 490, electronic.
234, yes. 235. Mr. Ford's very helpfully reminded me it's Section 235.
Ah, thank you.
491.
491 is 225.
Thank you.
Yes. It's page 506.
Hold on.
At the bottom of the page. A week in Chapter 1 of this part, which I don't think includes sections dealing with pay, a week ending with a Saturday, and otherwise means in relation to an employee's remuneration calculated week by week, a week ending with that other day, and in relation to any employee, a week ending with Saturday.
Yeah, and that's the general definition, Section 235.
Yes. In the general definition section for the Act.
Yes, thank you.
Lords and ladies, in the 20 minutes or so remaining, can I deal then with the approach to construction? And this is, I'm afraid, a part of my learned friend submissions where I will have to take you to some of the case law, because some of my learned friend submissions were extremely wide-ranging and dealt with some extremely deep waters. There is, we submit, as the Court of Appeal correctly held, absolutely no justification in this case for the deployment of the mar-leasing approach to construction. It is not permissible, we submit, based on authority in this court, to propose hypothetical scenarios or scenarios of others in which the working time regulations might afford less leave to others than under the Working Time Directive, in order for this appellant employer to seek to reduce the respondent workers' entitlements under the Working Time Regulations. The submissions are set out in paragraphs 55 to 69 of our case, but I do want to take you, and it's necessary to do so, I'm afraid, to the key cases on these concepts. Can I take you first to the case of Zed and Hackney, which is at tab 12 of the authorities bundle, page 736. That was a decision of this court given 13 months ago. Judgment being given, lead judgment by Lord Sales, agreed with by the other members of the court, including materially for present purposes by my Lady Arden in her concurring judgment. This was a case involving the lawfulness of the allocation of social housing under an agreement between a local authority and a charity. The local authority nominated applicants for properties owned by the charity. The charity gave priority to members of the Orthodox Jewish community. That was challenged by the appellant, who had applied for social housing but was not a member of that community. Unlawful discrimination under the Equality Act. It was admitted the arrangements were discriminatory but contended that they were justified, and those principles positions are set out. I'm afraid I haven't time to take you to the paragraphs. In paragraphs 1, 2 and 6 of Lord Sales' judgment. The relevant issue for present purposes was the proportionality defence in section 193, subsection 2, paragraph B of the Equality Act. And it was contended by the appellant in this court that she'd been discriminated against on the grounds of race or ethnic origin, contrary to the relevant EU directive. So at paragraphs 8 to 9 of the judgment. And that the proportionality defence in section 193 should be read in accordance with the mar-leasing principle. Can I just take the court to paragraph 21, where the proportionality defence is set out by Lord Sales. That's at page 745. You see paragraph 21. The defence arises if there's 1A, action in pursuance of a charitable instrument, and B, the provision is within subsection 2. Subsection 2 provides two disjunctive provisions. Firstly, it's proportionate means of achieving legitimate aim, or, independently of A, for the purpose of preventing or compensating for a disadvantage linked to the protected characteristic. So there was A or B within subparagraph 2. The issue was whether the race directive, the EU law, required subsection 2B to be read as including an additional requirement of proportionality, which already applied in the alternative in A. Can I take the court to what Lord Sales said about that? Paragraph 53 on page 754, dealing with the submission as it had been made in the Court of Appeal, he recorded there what Lord Justice Lewison had held, that since the appellant had been discriminated against on the grounds of religion, not falling within the race directive, the appellant was not able to show the Marleysing principle of sympathetic construction. It was not open to the appellant, this is Lord Justice Lewison's judgment being set out by Lord Sales, to say that in some case other than her own, there might be a conflict between section 1932B and rights under the race directive, where EU law might trump the domestic provision, either in the sense of requiring a conforming interpretation to be adopted pursuant to the Marleysing principle, or in the sense of requiring disapplication, and then indirectly to seek the benefit of EU law in her case, although no relevant rights of hers under EU law were in issue. There are a number of issues on appeal to this court, which I will, for your note, are set out at paragraphs 58 and 59. The policy was held to be permissible and proportionate, see paragraph 88, and also that it did not involve direct discrimination on the grounds of ethnic origin, see paragraph 89. From paragraph 95 onwards, Lord Sales addressed the remaining issues, including the Marleysing point, and his reasons are summarised at paragraph 97, the first being that the substance of the proportionality requirement in EU law was already met in section 1932B, his conclusion being at paragraph 110. It's the second reason, at paragraph 111 onwards, that is material for present purposes, because Lord Sales, if you turn up paragraph 111 at page 774, said that reading in a proportionality requirement into subparagraph B would render it redundant, would undermine a fundamental feature of the legislation and go against the grain of the legislation. That's paragraph 111. And he cites there some passages from Gaidan and Godin Mendoza on the Section 3 obligation of the Human Rights Act. And then at paragraph 112, he said the same reasoning prevented the court from interpreting section 1932B as including a proportionality requirement by reason of the Marleysing interpretative obligation. As with section 3.1 of the HRA, that obligation only requires and permits a sympathetic construction of national legislation to be adopted so as to produce compatibility with EU law when it is possible for the national legislation to be interpreted in that way. Possible. 113. In any event, Lord Sales considered the submission failed for the reasons he'd given at paragraph 54 in reliance on Lord Justice Lewison's judgment. He said this: no right of the appellant was engaged under the race directive. It's true that other people in other circumstances might have rights under that directive which are affected by a charity's actions, but that does not assist the appellant in her case. And then I'd invite the court to consider carefully paragraph 114, which sets out the proper approach to construction in these circumstances. And in particular, the fact that Lord Sales said very clearly that in the third line by letter F, unless the person who is affected by it can show that this would be incompatible with their convention rights under the HRA or some provision of EU law as applied to their case, only then, said Lord Sales, do the special interpretive obligations under Section 3 or under the Marleysing principle come into play. So, and then Lord Sales goes on to deal with the point that there may be different interpretations of legislative provisions depending on whether the EU law rights are engaged or not. Going back to my lady's judgment in the case of, I'm afraid I'm going to pronounce it wrongly, Gingi.
Yes, absolutely, where there were some provisions which had to be interpreted in accordance with the EU law and some not.
Indeed, lady, yes, and you proved the passage in Benyon, which was unsupported by authority, but then your judgment became authority for it. Crucially, the final sentence: if the position were otherwise, convention rights and rights under EU law would be given disproportionate effect in domestic law, and statutory interpretation would become an exercise in the imaginative construction of theoretical cases in which such rights might be an issue. in order to change the interpretation of legislation in cases where they are not. We say that is exactly the argument being put forward by my learned friend in reliance on other scenarios, other than Mrs. Brazel's case, to seek to reduce her rights under the working time regulations. It is not permissible for the reasons given by Lord Sales in Z and Hackney.
So to that extent, I think the submission pot was you can't pick and mix mar leasing. In fact, you're indicating that that is precisely, in one sense, what one can do.
Well, it's not pick and mix mar leasing, Lord. It's does the mar leasing obligation arise at all? What you can't do is seek to ride on the back of a mar leasing point that might be made in another case by someone else, which is exactly what my learned friend's submissions were. And to say that the legislation should be construed in your case, where you have no rights yourself engaged, in your favour. And that is precisely the submission that my learned friend made, and precisely what Lord Sales said should not take place.
Ginji is a quite extreme case because it was the one provision which applied to certain applicants and had to be given a conforming interpretation. But when it applied to other applicants, the very same provision did not have to be given as conforming.
Precisely in the benefits legislation.
I just thought that would assist my lords.
Yes, that's precisely what my lady's judgment was. To similar effect is what, and I'm given the time, I will just give you the references. To similar effect is what Lord Brown said for the majority in the Hurst case on coroners and inquests. That's referred to by Lord Sales. The judgment is at page 726, paragraph 52. And Lord Brown said there, in fact, I'm afraid better just turn it up. I'm so sorry. 52C, just next to letter C on page 726, where the mar leasing approach applies, the interpretative effect it produces upon domestic legislation is strictly confined to those cases where, on their particular facts, the application of domestic legislation in its ordinary meaning would produce a result incompatible with the relevant European Community legislation. To similar effect was the speech of Lord Roger at paragraphs 11 to 14 on page 715. So the appellant's case, we submit, fails on all three of the bases set out by Lord Sales in Z and Hackney. The ordinary meaning of the words in the regulations precludes a scheme of accrual of the sort proposed by the appellant. The meaning is not incompatible with EU law as applied to Mrs. Brazel's case. In fact, the appellant's complaint on its case is the scheme is more generous than EU law. In any event, you can't, we submit, interpret this statutory scheme with the features I've taken you to so as to produce the result the appellant wants. It would require legislation. And albeit it would produce, in practice, an undesirable result were you to adopt the point and to its logical conclusion, learned friend hasn't, in my submission, sufficiently dealt with the point that Regulation 13A, being the domestic legislation, even though it includes the same words, see my lady's judgment in Gingi, which I pronounced wrongly again, I think, even though it includes the same words, they can be construed in different ways depending on whether the European right is engaged. Learned friend's reliance on the fact that this instrument does include the same words in both regulations is not a sufficient answer to that point. That also feeds, of course, into the workability of the appellant's proposed solution, which would have you adopt, which would, on this premise at least, have different schemes applying to Regulation 13A and Regulation 13A rights. And even the mar leasing approach has its limits. They're set out in the case of Guidan, in the speeches of the House of Lords under the HRA Section 3 obligation, and I commend to you Lord Roger at paragraphs 110 and 115, pages 685 to 687. They're set out in the FA Premier League case, the judgment of Lord Justice Etherton on the copyright provisions, which we cited in our written case at paragraph 61, where he says that you cannot sweep aside the wording of national law by reliance on a directive and encroach on the legislative role, which we submit is precisely what the appellant invites you to do. And a similar effect, albeit historic but nonetheless good, is what Lord Diplock said in the Duport Steeles case regarding legislative intervention and legislative choice legitimate legislative choice. And we submit there are legitimate legislative choices that would have to be made if the appellant scheme were to be adopted. So for all those reasons, there is no basis, we submit, for a mar-leasing approach or for this scheme to be altered in the way that the learned friend submits. Can I also then deal with the risk management partners case upon which my learned friend relied? There is no requirement, we submit, as a matter of EU law, to do what the appellant seeks to have you do in this case. The reliance on the risk management partners case does not support the appellant's arguments. In any event, any more general interpretive obligation cannot be as strong as the mar-leasing point, particularly in the context of employment law involving legislative choices. Lords, ladies, the risk management partners case, as my learned friend said, involved damages claim against a local authority in relation to the provision of insurance. It's important for the reasons given by Lord Mance in the subsequent case of United States and Nolan, to which we refer, and I'll endeavour to take you to briefly, if I can, in the time available, to look at the reasons why Lord Hope and Lord Roger, who both gave judgments with whom the members of the court agreed, dealt with the appeal in that case. The issue was not the sort of issue raised by the appellant in this case. It was an exemption from the entire scheme of the directive. And paragraph 22, my learned friend took you to, it's at page 790. It was described by Lord Hope as a significant and policy-based exemption, applying in some member states but not others if the appeal was to go otherwise. Of course, in this case, the directive gives quite wide freedom to member states to adopt solutions in fulfilment of the directive. It is not a significant policy-based exemption. Secondly, paragraph 23, the exemption did not depend on the meaning to be given to particular words or phrases in the directive. Not this case. And thirdly, paragraph 24, which my learned friend didn't take you to, the issue was about the scope of the directive, and indeed the final sentence of Lord Hope's judgment. If the TECAL exemption were to be held not to apply to the 2006 regulations, it could only be the purpose of the regulations was to apply the public procurement rules to relationships that fell outside the regime provided for by the directive. That would not be a permitted use of the power, namely that in Section 2 of the European Communities Act. So there's no issue here as to that sort of difficulty. So this was a case about applying an exemption and about regulations which otherwise construed would have been outside the scope of Section 2.
But here, this is making it clear that gold plating, as somebody referred to it as earlier, doesn't go beyond the powers of Section 2.2.
Yes, this was a case about scope.
Yeah.
The USA and Nolan, which I'll take you to now in the remaining time I've got, demonstrates the point that my lady's just made. And finally, by the way, paragraph 25, Lord Hope said that the result could be achieved in the final sentence without doing undue violence to the words of the regulations, because this was simply holding, by implication, that the regulations did not apply in this scenario because of the TECAL exemption. And Lord Roger, I don't ask you to turn it up, but his judgment was to the same effect at paragraph 92, where he held that the TECAL criteria describe situations where the regulations simply have no application. And none of these considerations we submit applies here. Learned Friend's written case says that the issue is whether the exemption should be read into the regulations. Well, that's not with respect right. There was no reading in here. It was whether the exemption meant the regulations did not apply to this scenario at all. And you can see all these points from this court's decision in the United States and Nolan. That is behind tab 16, Authorities, Volume 3, at page 1658. That was a complaint by an employee at a United States military base in Hampshire of failure to consult employee representatives in relation to collective redundancies. And the judgment was given by Lord Mance, Paragraph 14, where he refers to leasing, the Vodafone case, which is also referred to in the written cases in this case. And at letter F, just above letter F, he says, where a directive offers a member state of choice, there can be no imperative to construe domestic legislation as having any particular effect so long as it lies within the scope of the permitted. When the directive allows a member state to go further than the directive requires, there is again no imperative to achieve a, in quotes, conforming interpretation. And then he goes on to discuss risk management partners, where he said the Supreme Court implied and into apparently unqualified wording of the regulations the limitation that we've just looked at. Paragraph 15, he notes that the directive in issue in the Nolan case left it open, as with the Working Time Directive, to member states to apply or introduce even more favourable laws. Of course, that was not an issue in TECAL because it was an exemption from the regulations in the first place and the regulations in the directive. And then Lord Mance discusses the risk management partners case and the TECAL exemption. And he sets out, I won't take you through them, paragraph 19 onwards, what was said in the judgments in that case. And the points that I've made regarding the scope of the regulations and the directive, the significant and policy-based exemption, and distinguishes risk management partners. And he said in paragraph 20, in the fifth line down, in relation to that case, the Supreme Court's reasoning is, however, important, and it was and is important in that case for those reasons. It can't be relied on, we submit, to demonstrate there is any imperative to have any particular effect or achieve a conforming interpretation. And that is a complete answer, we submit, to the appellant's reliance on risk management partners. There's no basis, we submit, for any construction of these regulations based on these cases, or indeed any principle of ordinary construction, which could lead to the result that the appellant seeks. As Lord Justice Underhill said, they all do violence to the statutory language. In any event, they are not, for the reasons I've given, permitted. Lords and ladies, that concludes my submissions in relation to construction, and on the other issues, we rely on our written case and on the oral submissions to be made by Mr. Ford, unless I can assist you further.
Well, can I just ask, the calculations annex that the appellants have put forward, do you accept that the answers that annex gives to those examples, which is said to be the respondent's approach, that those correctly apply the provisions in the way that you say they should apply to those hypothetical workers? I understand you say, well, never mind if those workers, if it ends up not giving them the leave they're entitled to, then they may have a leasing point, but that doesn't help the appellants here. But I don't know if anywhere you've sort of gone through those and commented on them.
Well, they know that we have dealt with them in our case. The intervener has as well, given and set out the problems with them that arise in terms of the interpretation. In relation to, for example, paragraph 35 on page 114, where there's the reference to how is 10 paid days of leave calculated. Well, my lady picked up the point with my learned friend as to how one looks at a day of leave by reference to the government guidance. So my learned friend's argument was it is impossible to do this except to sort out what a day means, except by adopting the accrual approach and the so-called conformity principle. But my lady picked up the point that the government guidance itself says that you can do this by reference to a reference period, and my learned friend's argument is that one simply can't do it any other way. So these calculations are based on a number of incorrect premises and assumptions which we've set out in our written case. Lady, those are our submissions.
Thank you. Mr. Ford.
my lords, my ladies. First of all, thank you for the permission to intervene. We endorse the submissions for Mrs. Brazel. We too say the Court of Appeal is an impeccable judgment and should be upheld. And in the short time available, I want to focus on three areas. Firstly, the background and history to the working time regulations. Secondly, the Court of Justice cases, including Greenfield. And in the course of that, I will address the Regulation 2.2 point my Lord Hodge raised. And thirdly, why we say the appellant system is impermissible as a matter of interpretation. It crosses the Gaydon boundary, but we're not even in Gaydon territory, or Marleasing, to use the AMRO rules. And our fundamental point is that both the Court of Justice principles and the domestic rules of construction chime together. A new system in which the entitlement to leave accumulates based on the individual's working pattern across the year, as proposed by the appellant, can only properly be achieved by legislation. It's far beyond the scope of permissible interpretation. Now, Mr. Glynn has again reformulated his case, and now it seems to be that he's saying that a week means the average amount of work done in the leave over the leave year. But notice that's also based in hours. He's not saying you do it in days or weeks. He's saying it's the average amount of hours of work done in the leave year over the leave year. Now, the scale of what is proposed, therefore, is huge, because while he's talking about irregular workers working irregular hours, in fact, we all work irregular hours now. And you can see that we've given some of the data in our case at paragraph 37, EF 173. The time of a worker clocking on and clocking off at a factory and working fixed hours is gone. Everyone is an irregular leave worker. Secondly, he's also introducing an accrual system. So everyone is going to accrue leave based on how many hours they work, which again is a complete novelty compared to the regulations. And it will affect everyone who's paid a salary. It's not sufficient simply to say, well, for some people they're paid a constant salary, so it won't affect them. It will, in particular, because Regulation 14, in every case, requires an assessment of the entitlement. So in every case, we have a new system based upon the average number of hours worked across the leave year. It doesn't take me to tell you this has enormous practical implications, because it will require a system of recording hours. And it can't simply work on pay, as Mr. Glynn says, where you look at paid hours, because pay is not a proxy for work. You will have to look at actual work. That's the language of the Court of Justice. So you will have to have systems in every employer and every workplace in the country for assessing actual work. The other point to say by way of introduction is he and this is relevant to my Lord Hodge's Reg 2.2 point, he is saying that the Court of Justice is effectively defining a week. He is saying his definition is entailed by the judgment of the Court of Justice. It follows logically from it. If he's right about that, every single national system that has come before the Court of Justice is inconsistent with his system, because every system we've seen has not adopted accrual based on hours. And if I can just give you the references to the various systems that we have before us. The Hine reference is 895. That was days. The Brandis system seemed to be an entitlement like working time. That's EF 851. The DICU system in Romania was based on days. That's EF 948. And the Dominguez system in France was based on days. That's 1818. So if he's right and a week means the average amount of work done in the leave year over the average amount of hours of work done in a week over the leave year, every European system we have seen is incompatible with the directive. And the short answer is that Greenfield is not laying down a definition. Greenfield is simply giving an overarching principle as to how you calculate leave, but leaving member states to work out the precise system. It is a principle, not a definition, and therefore it has no effect via the conduit of Regulation 2.2, but I'll come back to that point later. So can I just quickly begin with the background then? And the first point to note is that Mr. Glynn's submission on the meaning of how weeks works for irregular workers is entirely inconsistent with the original consultation paper. Now this is begins at EF 2206. And the first point to make is that if one looks at page 2211 and paragraph 7 on 2212, you can see there was very detailed consultation about these regulations, very detailed, with the aims of ensuring that they were practical, comprehensible, and workable. And at paragraph 123, which is in the chapter dealing with annual leave, the government, at page 2217, the government set out how it was intended that the working time regulations would operate. Now, at the time, the entitlement was only 3 weeks. There was an initial transition period. And you can see at the bottom of 2217, they expressly address the position of someone working irregular hours. Where a worker works irregular hours, the worker would have a right to annual leave that would allow them to be away from the place of work for 3 weeks. In other words, it's a fixed entitlement in weeks. It has no relationship with the working pattern. And there is nothing in any of this consultation or any of the other ones to suggest of a system of accrual based upon 12.07% 7% of hours. Nothing, never mentioned. I'm only pausing because I can see Lady Rose.
No, you're allowed to be away for 3 weeks, but the amount, you have to work out how much of that 15 days or 21 days when you're not going to work is annual leave. That's the problem, isn't it?
No, you don't, my lady, with respect. The annual leave just means a rest period.
Well, you have to work out, there are circumstances in which you have to work out how much of that you need to be paid for.
Pay works differently. A week system expressed in weeks simply means you have that right to a period of rest. It does not equate to a release from an obligation to work. For what it's worth, that's dealt with in Transocean by Lord Hope, because there they were considering circumstances where people may have no obligation to work at all, but be given leave. And that was also dealt with, incidentally, in the Court of Justice in Stringer and Ainsworth, where the government's argument in the Court of Appeal was, well, leave, you can't have leave because leave means obligation to work. No, says the Court of Justice, leave just means a period of rest. And for what it's worth, it's also dealt with in some of the language versions, which don't use leave. For example, the Spanish says vacaciones. So
you have to know if the worker is entitled to that leave,
yes,
because he may ask you for some more.
Yes, but you know the entitlement because the entitlement is fixed, in this case at 3 weeks. Mm-hmm. So the worker says, I want 3 weeks off. You say, that's your entitlement, you can take it. That does have the effect, as my lady raises, of translating into different days off work, contingently. But that's contingent, not a necessary consequence. And it's easy to think of circumstances where you owe no obligation to work, but you can still have leave. Factory shutdowns, school teacher holidays. But there's the clearest statement that 3 weeks leave meant 3 weeks off work, and a week meant a week. The second point to note is that right from the outset, the regulations adopted a very detailed scheme which could not possibly be derived from the few sparse words in Article 7. There was nothing in the background to the directive, for example, to suggest that pay meant normal remuneration. All we had was the 10 or so words saying Article 7 means paid annual leave. So right from the outset, the government had adopted a very detailed code, the legislator adopted a very detailed code, which might or might not have gone beyond the directive. In a sense, it was indifferent to it. But it was adopted, and for example, it adopted Regulation 14. The directive does not require a payment in lieu on termination. The regulations nonetheless adopted it. So the obvious intention was that the regulations would be the primary source of the detailed rules. It was the regulations that employers, workers, and tribunals would look at to provide a scheme in accordance with the consultation which was practical, comprehensible, and workable.
So why, if irregularity in work is the fashion of working, and if the consultation was so detailed and the policy making so detailed, that there was no specific provision to deal with those who were casual workers and with irregular hours?
Because the way it was to be dealt with was just giving them 3 weeks off work. So you can have your 3 weeks off work. That meets the directive. It's simple, it's clear, it's workable. You don't calculate your hours. You don't do any of these calculations. You don't have any of this system of accrual by which you're supposed to work out how much you've accrued to date. You've got the right from day one. Well, initially there was a 13-week qualifying period, but it went. Have the right to 3 weeks off.
So is there any direct discussion of this point that we're concerned with?
Not that we know of, but you can see that in the consultation paper itself, the government did raise, well, are there any problems with it? And this system, and they've done it in other other.
So was there a response to consultation document?
I'm afraid we given the time that since this was done in 1996, Mr. Purchase managed to find this consultation paper. We can't find the responses to the consultation.
Yes, I thought departments were meant to put all their documents over a certain age into the National Archives.
Well, if so, my lady, I apologise, but we haven't found them.
That'd be useful to know.
But there were questions saying, are there practical difficulties with this approach?
Mm-hmm. Yes, indeed, one would expect the employers' associations or the employees' associations to make very detailed responses to government.
And we see the same when it came to the 2007 regulations, which I'll come to shortly. Then, of course, the next thing we get is so that was the consultation paper. We know that the leave was meant to be expressed in fixed weeks because that's what the regulations said. So if we turn to the form of the regulations as they were enacted, which begins at 594. Firstly, they said in Regulation 13, you're entitled to 3 weeks or 4 weeks. They just said that. But secondly, and importantly, they adopted Regulation 14 at page 599. Regulation 14 only works on the supposition that, save in the first leave year, A is a universal fixed entitlement in weeks. That you know at the time. That you know at the time termination takes effect what it is. And it will ordinarily at this time be 4 weeks, now 5.6 weeks. But you have to know it at the time in order to do the calculation. That is A. Now, on the appellant system, A is unknowable, because A is based upon how many weeks, the entitlement is based upon your average hours over the leave year. When termination takes place midway through the leave year, ex hypothesi, you do not know that figure. So Regulation 14 is unworkable on his account. It has to be redrafted.
So it was done this way for simply ease. There's no social justice problem about this.
I think it corresponds with exactly what was said in the consultation paper, that it's about workability and simplicity, because you have a simple entitlement in this now 4 at the time, now 5.6, which you feed into the calculation, and therefore it's 5.6 times the proportion of the leave year that's elapsed, times a week, less what you've taken, times a week's pay.
And when there was the 13-week lead-in, so for 13 weeks you had no entitlement, and then on week 14 suddenly you got the 3 weeks entitlement. Is that how it worked?
Yes, that's how it worked under before BEC 2. But Regulation 14, there's no answer in the case to how you interpret it. It's not dealt with in any of the examples. They say coyly in their calculations annex, we ignore termination partway through the leave year or first leave year cases. And the reason why they do that is because they know Regulation 14 is unworkable on their interpretation. Because A has to be something else, which you don't know. Now, the reason why Regulation 14 is so important is because, as Mr. Gullick has explained, every worker who works on a short-time assignment has their holiday pay calculated in accordance with Regulation 14. Because they get to the end of the assignment, and it's then Regulation 14 bites, and therefore you end up saying, right, how much holiday pay are you due?
You might have an employee who, in fact, doesn't stay the course as well, and you need to make an appropriate arrangement.
Well, it applies to everyone whose leave terminates during the leave year, so every single worker in the country, but critically, the very workers that the BEC 2 decision said it was intended to protect, those on short-term contracts. Regulation 14 is critical for them, but they will never work a full leave year. So they will never have an average number of weeks over the leave year. So Regulation 14 at the moment is in the dustbin. And the same applies to Regulation 15A, because after we got the BEC 2 decision, the government could have just said, well, we'll delete 13.7. They could have just said, we'll delete the 13-week qualifying periods and sort it out. But it didn't. It put in place the system of deemed accrual that we see in now 15A. And again, this is inoperable on the appellant's system. If you look at page 535, oh, sorry, I'm on the wrong page. If you look at 525, that's the statutory instrument made after BEC 2, and it's at 526. Where we get 15A, where there's the deemed accrual at the rate of 1/12 of the amount specified in Regulation 13.1. So here's your short-term worker working regular hours. How much do I accrue? Answer, 1/12 of, at the time, 4 weeks, now 5.6, 1/12 on the first day of each month. What payment do I get on termination? Regulation 14. The system works. It's clear. It's operable because it's got fixed universal entitlements based on fixed weeks for every worker. If Mr. Glynn is right, 15A depends upon what the average number of weeks you worked over the whole leave year were. But you won't have worked over a whole leave year because this is about first year of employment. So again, 15A has to go in the dustbin.
And again, you presumably say that this will apply to most employees, save only those who start work on the very anniversary of the leave year.
Yes, it applies to every worker in the country. And again, it's of critical importance to the short-term workers, because they need to have a system, but it applies to every single worker in their first leave year, and it assumes an accumulation based upon 1/12 of now 5.6 each month.
Which you say is contrasted with no accumulation, and Mr. Glynn says is contrasted presumably with the accrual basis.
Well, Mr. Glynn, as you can see from his fixed leave year example in the calculation annex, and in answer to questions to you, my lady, was putting up a new system of accrual, apparently, where you work out how much leave you've accrued to date based upon 12.07%, and then the worker can only take so much of leave as they have accrued to date. That is at complete variance with Regulation 15A. So 15A needs to be rewritten, but we've had no explanation how. It doesn't take me to tell you that these are cardinal features, to echo the language of Lord Nichols and Lord Roger in Gaydon, of the legislation. And that also sets the background to 2007, because the 2007 regulations were passed at a time when there was no Court of Justice decision suggesting leave accumulated. That didn't happen until Land Tyrrells in 2010. So no one knew about this conformity principle in 2007. Yet, according to the appellant, apparently Parliament intended to adopt it. But if you look at 992 in the consultation paper, at the bottom of the page there, once again, the government proposes to increase that entitlement to 5.6 weeks pro rata for part-timers. Well, that's just saying pro rata means different amounts of time off work. But these are the critical words, and expressed as weeks to reflect the differing work patterns that many staff work, where daily patterns of work may vary considerably. In other words, it was adopting exactly the same system as it had adopted in 1998, where the entitlements were expressed in weeks.
So what do you say that the words pro rata for part-timers mean there?
What they mean is about the effect of a leave system expressed in weeks translates into different periods of time off work, depending upon whether you work part-time or not. That's all those references mean. You have a universal entitlement to 1 week to 4 weeks leave. If you work 2 days a week, that means 8 days off work. If you make 5 days a week, it means 20 days a week. But they do not affect the universal entitlement. But the other matter I want to draw attention to here, and I'll only say so briefly, it's summarised at 533, is the detail of the consultation. Now, it's summarised in the explanatory memorandum which went to Parliament, which we find at 533, where they explain at 7.3 to 7.4 and 7.4 the consultation. Now, this gives you some idea of the sorts of numbers that are involved: 340 responses to the first one, 650 to the second one. And it also involved an empirical survey, C7.2, and it involved full assessment of the administrative costs to employers of the various systems. You can see that at 5.3. You can see that in the detail of the memorandum itself, which is, the regulatory impact assessment, which is attached at the following. If you look at 540, for example, they assess the administrative costs to employers of the various systems. Now, our point, of course, is that Mr. Glynn's proposed system potentially engages enormous administrative costs, because it seems every employer in the country, I hesitate to call them irregular workers, for anyone working irregular hours, which is frankly everyone almost, has got to have a system of recording their hours. That, we say, is the sort of system you can only properly introduce via legislation. Only legislation is suitable for assessing the empirical effects, consulting on the detail, and so on and so forth, and producing the detailed regulations at the end of the day to give effect to them.
Is that because you'd have to have sanctions on employers who didn't fulfil their obligations?
Frankly, my lady, I have no idea, but you may have to have rules on the burden of proof. I mean, what happens if there are no records? Who bears the burden? Mm-hmm. But you can see immediately the administrative costs of this are enormous, because think of all the workers who opt out of the 48-hour maximum working time, and we've provided the figures in our case for that. There are millions of them. Apparently their hours have to be recorded. Piece workers, or anyone working at home having to keep a note of their hours. Painful enough doing it when you're at the bar. But you imagine the systems that sort of system needs an assessment of the administrative costs.
And these matters could well have been the considerations for producing what some would describe as an eccentric or erratic system.
Yeah. Yeah. They may be some of the price of legal certainty, but they're the system that was adopted.
That policymakers are entitled to consider.
Yes, and without being disrespectful, I would also say this court, or Mr. Glynn's calculation annex, is not the place to consider the potential empirical effects of a detailed system of this kind. A fundamental change to how working holidays is to be calculated, completely at variance with the existing system, which poses all sorts of problems for employers, employees. And these are unusual rights, because they're not rights that are simply exercised when you get to the tribunal. They're rights which are exercised every single day by every single employer.
And it's not suitable, you say, for us because it's not a mere desktop exercise. It has to be done in the context of the workplace.
Well, as a very clever friend of mine described it, it's a polycentric question.
That's Ron Fuller.
Oh, well, that must have been where he got it from. I'm sure it is, actually, yeah. A polycentric question which the courts are not suitable to adjudicate on. So against that, can I come to the Court of Justice decisions, which I'll try to deal with briefly. Now, they're really in two categories. They're about cases where the worker changes his or her working pattern, and they're in favour of the worker. The rights to 4 weeks leave can end up being spread in practice over longer than 4 weeks. That's a Brandis type case. Because days of rest accumulated while working more days a week can be cashed in against days when you're working fewer days. Or there are cases where the obligation to work is wholly suspended by contractual agreement or as a result of taking statutory leave. That's Hyman, that's Hine, that's Mazchek, that's Dicku. So Mrs. Brazel's case isn't in either category. She's not changed her working pattern, as my Lady Rose pointed out. She's not seeking to argue she's entitled to more than 4 weeks under the directive. and her work relationship wasn't suspended at any time. So, in effect, the Court of Justice has never actually considered circumstances like hers. But what we say is that all the Court of Justice has laid down is an inchoate general principle that the minimum period of leave accumulates and is calculated as a function of actual work. And it's inchoate because it does not dictate the concrete rules with sufficient legal certainty that member states may adopt, including all member states in the United Kingdom. Now, the first key point is none of the cases affect what is meant by leave qualitatively. Leave just means a period of rest. The second key point is you can't begin the exercise that the Court of Justice undertakes in these cases without a starting point of 4 weeks' leave. Now, the cases may adjust that entitlement in certain circumstances because of, for example, changing working pattern, but the very premise of them is 4 weeks means 4 weeks. That's the end result they're trying to achieve. Now, the best the appellant's case gets is Greenfield. And it's really the one paragraph in Greenfield. It's really paragraph 32, because no other detail is given of how you calculate the entitlement other than in paragraph 32. This is at page 864. Now, in answer to my Lord Hodges' point, the first point we would say is all the Court of Justice there is doing is laying out the general principle of how member states approach the calculation. They are not prescribing any method. It could be days, it could be hours, it could be something else. They are not defining a week. The court is not there providing a definition of a week. Still less can you derive Mr. Glynn's meaning from it. You cannot derive from those few opaque words that leave out the meaning of a week means the average hours worked by the worker over the leave year. Because if that were right, it would mean no member state enjoyed any discretion as to how they gave effect to Greenfield. It would mean every member state in the EU would have to adopt Mr. Glynn's system. So actually, he's not just trying to rewrite the rules for the UK, he's trying to rewrite the rules for Germany, Romania, and everywhere else. And it's not what the Court of Justice is doing. They are not prescribing the units of accumulation. They're not prescribing the rate of accumulation. They're not prescribing the period over which the calculation takes place. Maybe you look back 12 weeks, maybe you do it a year, maybe you do something else. And they're not explaining how accumulated hours translate into days or weeks off work. What does it mean if I've accumulated 12 hours, 50 hours? It's meaningless unless the member state has a mechanism for translating that into periods off work. In short, you cannot derive a definition from that paragraph, and nor can you derive Mr. Glynn's system. Any number of systems may be compatible with it. It is not a definition. And if you want to see how inchoate the principle is, you also look at Hine, which is the relevant paragraph here is 29. It's at page 899. Now, the court cites the general principle in DICU at 27. It relates to periods of must in principle, notice those words, in principle, calculated by reference to periods of actual work. And go on to talk about Hines' case. And then they talk about how they're calculating it at 29, saying it follows from the case law cited at 27 above, that they're going to do a calculation for Mr. Hine. They do it in his case, saying that Mr. Hine did not perform actual work for 26 weeks. It is apparent then, in principle, again, emphasis of those words, only 2 weeks of leave are governed by Article 7.1. Well, it doesn't take me to point out to this court that that is not the same system as Greenfield. Because Greenfield says you calculate in hours or days. Here they seem to be doing it in weeks.
I mean, the oddity is that in section 2243, I think it is, dealing with the looking back for the 12 preceding weeks, it says you must ignore any weeks in which there was no remuneration.
Yes.
I'm not sure whether they had to say that in order to comply with something, or one can see why they said that. Otherwise, someone in Miss Brazel's position would earn a lot more holiday pay if she took her annual leave at the start of the school holidays compared to if she took it at the end of August.
Yes.
But where does that, how does that provision fit in?
Well,
with these injunctions that you have to reflect? I know that's to do with pay rather than leave. Maybe that's the answer.
it is the answer, my lady. Pay under the EU law has to reflect normal remuneration, which means remuneration while you're working. See Williams, see Locke. In fact, see Hine. The statutory scheme usually replicates that, but in some instances it's failed to do so. And the courts have managed to adjust it in accordance with Marley's thing to achieve that result. That's, for example, Locke in the Court of Appeal.
We're not concerned with the jurisprudence about Article 7, are we?
No. But this case is, that's why in Hines' case they said Mr. Hines' remuneration had to equate with the pay he got while working, but they did reduce the entitlement. But my short point is, and by the way, in Hine, the system was also based on days of accumulation. One cannot derive the, one cannot work out from the EU general principle what is the system to be adopted. My Lords, I'll wrap up. I won't say much about the wrap-up principles on the cases other than to say this, that in the context of examining how to give expression to 4 weeks leave in the circumstances of changing work patterns, the ECJ has only laid down an inchoate general principle. It has never prescribed a single method of accumulation certain enough to be applied by employers, workers or national courts across the EU. How you give concrete effect to that general principle is necessarily a matter for each member state. By the same token, nor can you deduce any particular system from the general statements of principles in the cases. Once more, we are in the realm of legislative choices. And my Lord Hodge, to deal with the point you raise about Regulation 2.2. Regulation 2.2 obviously presupposes a definition. It obviously contemplates something in the nature of a definition that can be derived from the Court of Justice case law and which you can then read into WTR. It isn't a license to disrupt the whole system of WTR by Court of Justice decisions. It doesn't say decisions of the Court of Justice are given without more effect. It's not that sort of conduit, perhaps like Section 2.1 of the ECA. The Court of Justice's cases all take as their fundamental premise that 4 weeks in Article 7 means just that, 4 weeks. That's the result they're trying to achieve. And the same terms in Regulation 13 must mean the same. At the risk of making the most tautologous statement that you may have heard, 4 means 4 and week means week. The cases applying the principle that leave is based on actual work aren't providing a definition of a week. They are just giving an overarching guidance to member states on how you calculate or quantify 4 weeks annual leave. They are not dictating that week means average hours worked in the leave year per week, or 0.21207 hours worked. The principle is far too uncertain to generate a definition. So Regulation 2.2 does not assist the appellants. I think I only have 5 minutes left, my lords. If you want further confirmation of that, also dealing with the Reg 2.2 point, it's to look at the concrete detail of the actual system proposed by the appellants, because it doesn't just go, it goes beyond simply saying it's 12.07% of leave. It also embodies a system of accumulation with its own rules. It seems to involve a system of carryover, because apparently there's a re-reckoning at the end of the leave year of how much leave you've taken, and then you have to decide whether you've used all your entitlement or not, which is in fundamental conflict with Regulation 13.9. You cannot carry over leave under the directive. So, once again, we say it's impossible to deduce, and it would be a logical deduction, the appellant system from the few words in Greenfield. And they themselves acknowledge this, because they themselves have proposed different systems. They proposed a system based on hours. They've also proposed a system based on weeks. And at one point, they seem to have a system based on days. See the transitioning down worker in their annex. I've already said that this system contradicts cardinal features of the working time regulations, to echo the words in Gaydon. It's in contrast with the universal entitlements in 13 and 13A. It's in conflict with Regulation 13.9 on no carryover. It makes Regulations 14 and 15A unworkable. And it also produces a nightmare for Regulation 26A. It also involves see Lord Nichols in Gaydon at 33, EF 661, I won't take you to it. The court taking decisions for which it's ill-equipped. And that's back to our polycentric question again, that this is a system which has been set up, with all due respect, drafted in someone's chambers. It's had no assessment of the empirical effects. It has far-reaching practical ramifications, which the court is not equipped to evaluate. See Lord Nichols in Gaydon at 34.
Well, can I just interrupt? One point that was put against that submission you've just made is that for a long time, this 12.7% system was being operated without, apparently, too many problems. I mean, is that not an argument against what you've just said?
Well, we don't know whether the 12 point, what system in fact employers were operating. We have very little detail of that. There's no evidence that everyone was adopting the ACAS code. Some may have adopted it, others may not. We simply don't know. And it's not really for me or for Mr. Glynn to say, oh, the 12.07% system was fine. We just don't know. I mean, one question that's always occurred to me was under that system, when they said you've accrued so many hours of leave, how did that translate into weeks? What did it actually mean when they said, well, you've now got 20 hours of leave? When the worker said, well, I want next Monday to Friday off, what did that mean? But as I say, these are really empirical questions which ought to be the subject of consultation in a legislative process. Assessing the administrative costs and so on. Two final points, if I may. Next, the scale of what is proposed is huge. It creates, quote, a wholly different scheme. That's Lord Rogers in Gaydon at 110 EF 685. When you stand back, this isn't something that can be done by implication. This is a complete rewrite of the whole statutory scheme from start to finish. And finally, my lords and my ladies, we say the amendments proposed are not clear. That's Lord Roger in Gaydon at 124. Mr. Glynn gives his definition, apparently, of what's meant by the entitlement. It means the average number of hours worked each week, worked in a week across the leave year. But that doesn't tell you anything about the actual detail of his system, because the detail of his system as to how much leave you can take is buried in the calculations annex.
Does that annex actually include, I don't think it does include, looking at actually Mrs. Brazel, what the difference would make as to the two ways of calculating her holiday pay? Have we seen that anywhere? What she was actually paid and how that was calculated, and what you say she should have been paid and how that would be calculated?
Well, it addresses pay because the pay ends up being a function of the entitlement.
Well, it does, because she's not actually going into work those weeks anyway.
Yeah, under the 224 system, pay is based on the weeks she works only. Under their system, the entitlement is reduced. It will be shrunk because it will be 12.07% of the hours she worked.
Yeah.
Therefore, by some mechanism, that would feed into reduced pay.
But I would find it helpful to see, rather than the hypothetical examples, what actual difference it would have made to Mrs. Brazel in 2020, say, or...
Yes, well, I think Mr. Glynn's already said it's about a difference between 12% or 17% of her annual earnings. But I think in the calculations annex itself, because she would be a restricted leave worker.
Yes, but is it possible to see the actual numbers?
For her?
Yes.
I don't have that, my lady, I'm sorry.
Well, maybe somebody else does.
But I suppose, if I may just finish, my point was that to work out actually how this system works, you're going to need to look at the calculations annex, because it's only buried in there that you see this system of accrual, that you see this system of re-reckoning at the end of the year. How is that meant to guide employers? Are you meant to exhibit the calculations annex to your judgment? I've got no idea. It raises a serious issue for legal certainty. My lords and my ladies, unless there's anything else, those are my submissions.
Thank you very much. Mr. Glynn.
ladies. Mr. Ford taught both me and my instructing solicitor at university, so obviously it pains me deeply that I rise to my feet to attempt to contradict everything that he has said. My lady, you asked as to what I can take you to is effectively the claim made by the claimant, and that's at page 452. And what happened to Mrs. Brazel is that she was paid on a 12.07% basis. And you can see at the figures at 452, for instance, these are over the period of time 2011 to 2016. You start with 5th of September 2012, and the figures are put out, and the cumulative shortfall is set out in terms of, I think, in terms of the annual leave under that, and she says effectively cumulative pay received and the cumulative shortfall over, for instance, a number of years. If one then goes to the bottom as the claim was advanced, perhaps the place I can find is page 459. Over the period of 2011 to 2015, you had a shortfall of some £2,000. Based on just using the 5.6 weeks times the reference period, ignoring all weeks not earned, and then using the system of pay as against what she was paid, which was the 12.07%. But if it would assist the court, we can certainly do two calculations based on, for instance, a year of 12.07% and also 5.6 weeks applying. And if it would assist the court, my lady, then that's what we shall do. And we shall attempt to agree that calculation with my learned friends and then email it in.
Thank you.
Thank you.
My lords, my ladies, just can I take you first, please, to page 604. Can I say that the reason I use the conformity principle and I didn't use accrual and pro rata is because I was worried also to an extent that I might not be traduced, and then friends are entitled to make their submissions and properly did so, but they might describe my system as something other than it is. And if one goes, and I say, and they call it my system, the system, but it's a system apparent from the working time directives. Now, in this
page number again, please.
Page 604, my lord.
604, thank you.
Page 604. In this case, we're dealing with Mrs. Brazel, who's an hourly paid worker. So I'll put the principle in hours. So when I say a week's leave is the average amount of work done in a week over the leave year, and if I put that principle in hours in this case, that's because Mrs. Brazel is an hourly paid worker. But what all this is required is that the entitlement accrues in units of time, and that may be in weeks, in days, in hours, and or fractions thereof under recital 5. So it's units of time. It isn't every case hours. It is in this case. And so it's wrong, I say, for my own friends to effectively ascribe it. I'm saying that every hour has to be calculated. It doesn't. Nor, as I was clear at the beginning of this, does it have to be calculated for someone who has normal working hours. Because their case is provided under the normal working hours, to which one doesn't have to, one has 5.6 weeks, which is multiplied straight away. And that is simple and settled. The difficulties arise in this irregular hours worker. And the difficulties arise as a result of the working patterns over the year. Now, it's also wrong, I say, to suggest that I'm submitting on a principle of accrual, that one can only take the leave that one has accrued. I haven't said that, and that isn't my submission. It is right that you can only be certain. With someone who is working irregular hours, you can only be certain of a certain amount of the fact that they've accrued a certain amount of leave at a date by what they've worked. That's true, but I am not submitting a system of accrual. It is right that a worker, and the example I've given, if I can take you please to the core volume, page 112. And what we've set out at 112 is what we've called the restricted leave worker, and that's the typical worker at page 113, where you can see, and we've simplified it at page 113, paragraph 29, those number of hours, but they are relatively chaotic, the number of hours being worked during the week. Now, what the conformity principle does is it brings sense, and it brings rigorous legal sense to answer the questions that the legislation demands have to be answered. The legislation demands that one knows what is 28 days, because the maximum amount of leave under Regulation 13A3 is 28 days. In spite of the fact that I've asked my learned friends to address what a day's leave is for an irregular worker, for a worker with no normal hours who's working irregularly, they haven't been able to formulate what a day's leave is. They simply fall back on 5.6 weeks, all the while criticising me. So be it. But what we do by our system is carefully work through, and we can show in each and every case what a day's leave is. If an irregularly working worker comes into the office and says, I have a funeral tomorrow, please may I take a day off, our system, the system of conformity, allows that worker to be given effectively for that day's leave to be calculated.
Well, you'd have to have a continuous recording system which did the calculation. I mean, in point of fact, unless you've done that, you won't know whether he, she's entitled to a day's leave.
Well, indeed, and it may be, for instance, that a worker comes in and says, I want to take more leave than actually I've accrued, and an employer can let the worker take more leave than they've accrued. But as we make it clear on the restricted leave worker, the example we've used is that the employer has used the system under Regulation 15, which neither of the parties have taken you to, which allows an employer to restrict the leave of a worker. And can I take you, please, to just show you it quickly in Divider 6. Sorry, page 584. I agree with Mr. Ford that a person working irregular hours might come in and say to their employer, right, I want to take effectively my 5 weeks of leave now. It's only 1 week into the leave year, but I want to take it now. And that would produce a calculation of what their working week is. If they've worked only 10 hours during that week, their working week is 10 hours. And they're then entitled to 5 weeks of leave, because they've asked for 5 weeks, at the rate of 10 hours a week, under the conformity principle. But the employer also has a choice that it can use Regulation 15(2) to serve a counter notice to prevent leave being taken. And indeed, many employers do that with irregular working hours. So it's not an accrual system. I accept a worker is given under this system 5.6 weeks of holiday at the beginning of the leave year. Where I differ with my learned friends is I tackle the really difficult issue is that what is that entitlement? How does that entitlement break down to a day? How does that entitlement break down when the worker increases or decreases, as irregular hours workers necessarily do over the year? And what we've done is, if I can show you, please, at page 112, we start with the restricted leave worker. And then we set out the different number of hours at paragraph 21. And at paragraph 35, we set out our case, as I repeated today, that the solution by the Court of Appeals analysis offers no solution as to how the entitlement to leave should be calculated. This is because their interpretation does not account for the working week. What's 10 days paid leave? How do you calculate the maximum 28 days? And there's no... What is 0.6 of a week for an irregular working worker? What is the duration of time of 0.6 of a week? None of my learned friends have answered that. The best that they could do was to go to page 968. And in answer to a question from Lady Rose, is how do you calculate that? And my learned friend, Mr. Gulick, said, well, if then what you do at page 968 is, in practice, if needed, employers may wish to calculate average days or hours worked each week based on a representative reference period. Simply put it rhetorically, now who's rewriting the scheme? Now who's writing a scheme with what is a representative reference period? It's not set out in the working time regulations. There's nothing there. The only side that offers a encyclopedic analysis and answers all the questions is by operation of the conformity principle. That finds its expression simply, although as a matter of difficult calculations, through 12.07%. So there's some kind of extra statutory a representative reference period. There's nothing in the working time regulations to allow my learned friend Mr. Gulick, who insists on that being insists on the regulations and the scheme as being the only appropriate way forwards. So we make no apology for the complexity, because people who work irregular hours have complex working arrangements, which none of any of this legislation was prepared to in the consultative or impact documents was able to look at. It just simply said 1 day a week or 2 days a week. For instance, can I take you down back to page 114? After a number of calculations at paragraph 39, and this is answering the question, and what we've done is we've given 3 different leave periods during the year. In a number of questions, what we've done at paragraph 38 is at the 30th week, the worker has worked some 370 hours and is working effectively at a working week of 12.33 hours per week. That 370 hours has been worked on 90 separate days, and therefore it gives 4.11 hours per working day. So we answer the question what at that stage a working day is, but that may need to be recalculated. And to give an example of the recalculation is if one goes to paragraph 51 of our example at page 116.
But that's not how the world works, because if you ask for the day off to have a funeral, to go to a funeral, the employer doesn't say, well, you're only entitled to 4.11 hours leave, so you can take tomorrow off, but you have to come back at 3:49 because you've only got that amount of leave.
I beg your pardon. You're given the full day off.
Yes.
You're given the full day off, but the entitlement, the freedom, what my lady Rose asked is if you're working 1 or 2 days, you're freed from the work obligation. You're given the full day off, but you're freed from the working obligation, which is translated to 4.11 hours. In the same way, if I work a 1 day per week as a part-time worker...
Why do you need to know that it's that entitlement if you're given the whole day off?
Because in that way you calculate the entitlement to the amount of time. Otherwise you end up being given some sort of rolled up holiday pay, or you end up being given more than 28 days of leave. You need to know to answer those statutory questions.
So if you're told you don't have to come in next Tuesday, that Tuesday may be more than 1 day's leave. Is that what you're saying?
No, I'm not saying that. If for instance, a person who regularly works on Monday 1 day a week and says, next Monday I want that day off, and that may equate, in that case,
yes,
that equates to...
You keep stopping us from talking about that situation because you say, no, we're talking about people who are working a few hours each day.
Yes.
So somebody who generally works 3 hours on a Monday and says, I don't want to come in next Monday because I've got a funeral to go to, right? So what relevance is it that they usually work 3 hours on that Monday?
So they usually work... So what one has done is, I don't wish to work to come in on, I wish to take a day of leave to go to a funeral, someone who's working regular hours. So they need to be freed from the obligation to work for that day.
Yeah.
But you need to pay them, that person isn't asking for 5.6, a percentage of 5.6 weeks of work, because you can't calculate it on my learned friends examples. You need to find out what 1 day of entitlement is. 1 day of entitlement being freed from work. And the 1 day of entitlement of being freed from work amounts to 4.11 hours.
But why do you need to know that?
Because otherwise one couldn't pay the person for that day that they're taking off.
So it is to do with how much you pay them for the day, rather than how much leave they're having.
No, they are both obviously related, because how much leave you have will translate to how much pay you receive. They correspond. We accept that but what we're trying to do is to apply a rate of a calendar week's pay to each week or each day of entitlement of leave. And so that's what we're doing by the 4.11. But it isn't simply a rate of pay argument, with respect, my lady. It's about, we say, the application of the conformity principle, and you have those arguments. If I may, take you, please, to my learned friend's arguments on Regulation 14. And they can be found, again, behind divider 6, I beg your pardon, and Regulation 14 at page 583. And my learned friend said that this would require a complete rewriting of Regulation 14 and 15A. And he's simply wrong about that, because the period of leave to which the worker is entitled, that is A. So if one looks at A, the period of leave to which the worker is entitled under Regulation 13, let's take the example after 6 months. A person is dismissed or leaves employment after 6 months, but has been working through those 6 months entirely irregular hours. A is 5.6 weeks of hours corresponding with the working week. So 5.6 weeks of time corresponding with the working week. It might not be hours, but in this case we say it is. So the entitlement is to 5.6 weeks of hours corresponding with the working week, times 0.5, because obviously they're leaving halfway through the week, less what they have taken. There doesn't need to be any recalculation or any redrafting. We simply say, my learned friends are frightening the horses on a system that worked for 20 years without problem. It is not a new system that we suggest, but indeed one which follows the principles clearly stated by the Court of Justice and incorporates them so that irregular hours workers, whatever their pattern of work, are treated in conformity with the directive. In respect of my learned friends' submissions as to leasing, we simply say that the point is a simple one, and it's captured at page 1566 of paragraph 22. And we say leasing requires, as the Supreme Court accepted in Russell and Transocean at paragraph 22, that the provisions of the working time regulations should be interpreted so far as possible in conformity with the wording and purpose of the directive. And I've given you submissions on the wording and purpose of the directive. And that's simply what we ask. In terms of the TECL exemption, again, that was a meaning ascribed to regulations, yes, as to an exemption, but the meanings ascribed to a set of regulations based on the clear purpose set out by the Court of Justice. And again, that clear purpose is set out in this case. In respect of recording every moment of work, that simply, we say, is again a submission to frighten the horses without any substance to it. We're talking about, in this case, hourly paid workers. It's paid annual leave. So it's paid annual leave clearly from paid work. And it's clearly every employer records the number of hours worked by, for instance, in this case, hourly paid workers. And we say that Greenfield inherently addresses the subject, the principle of all irregular hours workers, as does Brandes, because they increase and they decrease. And unless the conformity principle is applied, then not only will you not have the right amount of leave, but you might end up not granting people for leave. It's not a new scheme, it's the same as the ACAS interpretation. And in response to my learned friend's point that leave may only be taken in the year in which it accrues, and our system necessarily means that wouldn't happen because some leave would be granted after the end of the year, we say that's completely wrong. In fact, we are the only answer to the proposition that we can tell at 50 weeks, after 50 weeks of the year, how much leave is accrued and how much needs to be given. Yes, we need to know in the final week to ensure that that leave is given before the end of the year, but our system ensures, the system of the conforming interpretation ensures that appropriate leave is given. And my lords, my ladies, I realise I've gone over time, and the final submission I just want to make in respect of Regulation 14, 15A and 26A, which are all the same point, that they require some kind of redrafting. They don't. They're all parasitic on the entitlements on Regulation 13 and 13A, to which the entitlement conforms to the pattern of work. And the mischief in this case that we seek to address is not to reduce Mrs. Brazel's claim. She was paid on the basis of 12.07%. The mischief we seek to address is that all workers were clearly given the same entitlement to 5.6 weeks of leave. And where you have adventitiously absurd results, as you do in this case, then that must negate, we say, the claimants and the interveners' interpretation and support the one we urge on you arising from the conforming principle. My lords, my ladies, we'll draw up some calculations and agree them with my learned friends, and it will probably be tomorrow, I would have thought, by the time we can get those calculations. We'll try and put them as simply as we can. There may be a few notes as to disagreements, but we'll in any event try and put them.
Thank you very much. The court is very grateful to counsel who have addressed us today, and also to those who have assisted them in preparing both the written and oral cases and the documents which we have to consider. Interesting points have been raised in this appeal, and the court will take time to consider them and then produce a judgment. The court is now adjourned.